Greetings everybody. Welcome to Lawputra's YouTube channel. And today I'm going to discuss about the governor and its role in a state. Unlike the center in India, the state also has a bit of governance system. And due to this, the role of governor had been a debatable topic since the time the constitution was in making. So the episode basically raises questions on the role of a governor and the constitutional provisions regarding him. So first of all, talking about who is a governor. Article 153 of the Indian Constitution says that there shall be a governor for each state and one person can be appointed as governor for two or more states. Basically, the governor is the nominal head of the state executive, and by state executive, you all know that it is the policy making body of the state, and he is called the nominal head because the real decision making power rests with the chief minister. But all executive actions are taken in the name of the governor. And according to Article 154, the governor shall exercise the executive power either directly or through office subordinate to him. Now let's just quickly have a glance at the qualification and appointment of a governor. So according to Article 157, a person, in order to be eligible to be appointed as governor, must be a citizen of India, and secondly, must have completed the age of 35 years. And besides that, he must not be a member of either House of Parliament or of a House of the Legislature of any states, and he shall not hold any other office of profit according to Article 158. Always remember that a president isn't appointed. Instead, he is elected through an indirect election. And this is one of the major difference between the president and governor, which creates a drastic change in the roles of both of them. According to Article 155 of Indian Constitution, the governor of a state is appointed by the President of India. So, the Constitution gives a carte blanche to the center in the matter of appointment of a state government. He is neither elected by the direct vote of the people nor by an indirect vote by a specially constituted electoral college, as in the case with the President. Basically, he is a nominee of the central government. And just talking about the oath of the governor, so, according to Article 159, the governor, before entering upon his office, is required to take an oath or affirmation in the presence of the Chief Justice of the High Court, or if he is not present, in the presence of the senior most judge of the High Court. Further, let's take a look at the tenure of the governor. So, the basic rule is that a governor holds his office during the pleasure of the president, according to Article 156, Clause 1. Accordingly, the central executive can remove the governor or on any ground, as for example, bribery, corruption, violation of the constitution, etc. Subject to this overall condition, a governor holds office for 5 years. The governor may resign at any time by writing to the president. And according to Article 160, in a contingency for which the constitution makes no provision, such as death of the governor, the president may make such provisions as he thinks fit for the discharge of the functions of the governor of a state. In the case of BP Singhal versus Union of India 2010, it was held that the governors cannot be dismissed arbitrarily on the ground that the central government had lost confidence in him and he does not agree with its policies and ideology. Besides all these, the governor enjoys the same privileges as the president does under Article 361. And he stands in this respect on the same footing as the president. Even where governor's bona fides are questioned in the matter of exercise of his discretionary powers of appointment and dismissal of the chief minister, he cannot be called upon to enter his defense. And according to the Bombay High Court, the governor, while taking decisions in his sole discretion, enjoys immunity under Article 361. Now let's just shift to another point, that is the role of the governor in a state. So, the governor of a state plays a multifaceted role and he acts in dual capacity as a constitutional head of the state and as the representative. He is a vital link between the center and the state. It is his duty to keep the center informed of the affairs of the state. This helps the center to discharge its constitutional functions and responsibilities towards the state. So we all know that India is a union of states and not a federation of states, which implies that a union withholds more power in respect to the state. And because here a governor is appointed by the president, who in turn is a part of a union, therefore the governor acts as a representative of the president within a state, and has a unique position in linking the two sets of government. So we can say that governor acts as a bridge between union and state. Like an elder brother, he must represent the state's aspirations to the union, and like a postman, he must bring issues of national significance at the state level. Next, the governor serves as constitutional head of the state. In addition to performing various significant duties in regard to the state legislature, he appoints the chief minister and other ministers. And since the governor has a fixed term of office, he ensures continuity in the state's administration, while the chief minister may accordingly occasionally change positions. Moreover, the governor then serves as the center's agent when a proclamation of the state's constitutional machinery's breakdown is made in accordance with Article 356. Now, let's just discuss in brief about the role of the governor in summoning the houses. As per Article 174, the governor shall from time to time summon the house or each house of the legislature of the state to meet at such time and place as he thinks fit. The provision also puts on the governor the responsibility of ensuring that the house is summoned at least once every 6 months. Although it is the governor's prerogative to summon the house, according to Article 163, the governor is required to act on the aid and advice of the cabinet. Apart from all this, even though he is a nominal head of the state, he can exercise some powers over state executive, which pocket veto, suspension veto, send a bill to president for his recommendation, and some discretionary powers. Now let's just discuss some important judgments of the Supreme Court on the controversial role of the governor. Firstly, S.R. Bomai versus Union of India case, 1994. This case was about the powers of the governor to dismiss a state government under Article 356. The Supreme Court ruled that the floor test should be the only way to determine the majority of the government and not the subjective opinion of the governor. Next, Rameshwar Prasad case, 2006. This case was on the validity of the president's rule and the dissolution of the Bihar Assembly in 2005. The Supreme Court ruled that the governor cannot take decisions on the basis of his subjective assessments. Moving further, in Nabum Rabia case 2016, the Supreme Court ruled that the governor is just an executive and nominee and not an elected representative, and his powers flow from the aid and advice of the cabinet ministers. Use of discretionary powers for summoning or dissolving assembly sessions without the advice of the cabinet is unconstitutional. And further, in Karnataka Assembly case 2018, the Supreme Court ruled that the discretionary powers of the governor cannot be arbitrary or fanciful. Even the Sarkaria Commission of 1983, which reviewed the arrangements between the center and the states, had said that so long as the Council of Ministers enjoys the confidence of the Assembly, its advice in these matters, unless patently unconstitutional, must be deemed as binding on the governor. It has stated that the governor is a linchpin, which means a person or thing vital for an enterprise or organization. Further, the Rajamanna Committee emphasized that the governor of the state should not consider himself as an agent of the center, but play his role as a constitutional head of the state. It is only when such advice, if acted upon, would lead to an infringement of a constitutional provision, or where the Council of Ministers has ceased to enjoy the confidence of the Assembly, that the question arises whether the governor may act in the exercise of his discretion. Thus, summarizing all this, we can say that the state governor is a key functionary in the system envisaged by the Constitution. He is neither a decorative emblem nor a glorified cipher, but has an important role in strengthening federalism. Hope you have liked the topic and understood it. Thank you.